I'd like to talk to you a little bit about alternative dispute resolution. Basically, some things that you need to understand about this is why disputing parties seek alternatives to litigation. In other words, why do people want to go through ADR, which stands for Alternative Dispute Resolution, instead of having their day in court? Also, this is a great point to understand that the simplest form and the cheapest form of ADR is negotiation. And there are some basic methods of negotiation. It's a great skill that I advise you to learn early in business and in life because it will help you if you engage in negotiation in the proper way. We're going to also compare the various forms of ADR all the way from negotiation to arbitration. And there are some great comparisons to be made here in terms of expense, in terms of time, in terms of control, and those types of things. Some of these methods will fit very well for you to resolve disputes throughout your business life and your personal life. Very important to know the differences between arbitration and mediation and to know which is most appropriate for a dispute. And we need to talk about why courts have a very limited role in reviewing the actions of arbitrators and mediators. All right, let's start. You have two people with a different point of view. One example might be two people waiting in line to use the copy machine. Each person thinks they should be first in line, possibly. One person jumps up there and starts using the copier. The other person has a difference in opinion there. There's a conflict. There are two or more points of view. Conflicts can lead to dispute. So the second person in line says, hey, I'm supposed to be using the copier first. Then the other party says, no, you're not. I'm using the copier first. That's when the dispute arises. Conflict can be okay. It has sort of a negative connotation, but conflicts are going to arise and disputes are going to arise, and that's okay, but they do need to be resolved. So, the first step is usually negotiation. And negotiation is something that a lot of us do every day, whether we think about it or not. This is the process we use to persuade or coerce someone to do what we want them to do. There are many different styles of how to deal with that. So a response can be avoidance of the whole conflict and negotiation. There can be complete accommodation. For example, the second person in line says, go ahead, I'm going to let you go without any further discussion. There can be competition, there can be collaboration, and there can be compromise. Now, there are two types of negotiation I want to mention here. One is positional, and this is what people instinctively do. Good example would be a sale of your house. Let's suppose somebody comes up to you and says, or maybe writes out an offer to buy your house for $100,000. And you think to yourself, man, that's way too low. My house is worth $200,000. So you change that and say, I can't take $100,000, but I will take $200,000. Well, it's unlikely that people that far apart are going to meet, but if they did, they might meet near the middle at $150,000. Basically, the seller would start with a high asking price that's considered reasonable, and the buyer begins with the lowest reasonable price, and the gap provides room for give and take. Now, probably a more reasonable position would have been for the seller to have started with $175,000 and the buyer to start with $150,000, something like that, a little closer together, and maybe they would be able to go back and forth and eventually meet somewhere in the middle, or maybe not if one side's unwilling to budge. So it's kind of a competitive type of negotiation. Each party states their respective expectations. They don't really focus on any underlying conflicts. There's a better way to go, though, in many cases. Maybe negotiating just a price, not such a big deal, but there can be bigger disputes between people or businesses that like to do business together and want to continue doing business together. So how would that work? Principled negotiation might lead to a win-win for both sides. This requires more than this positional bargaining. So an example might be that a store buys television sets from one manufacturer, and that goes fine for a while. Then the store says, we want to agree to buy double that many television sets for the next 6 months at a set price. The manufacturer agrees. Well, the manufacturer may have to pick up production, and maybe there's some kind of problem in the production so that the television sets are faulty. What if that happens? Well, the store could just say, our position is we're not going to buy any more from you. But the manufacturer may say, well, that's not going to work. We'll just sue you for millions of dollars. Well, those two positions are pretty far apart, and it may be very hard to work this out because manufacturer can't afford to settle it. So what are you going to do? So instead, you might go to principled negotiation in the hope that the manufacturer and the store can work out something where they can work together later, and both parties win. Important to this process, first of all, is communication. There needs to be clear communication between the parties. It's not good if the store never told the manufacturer why they just suddenly cut off the purchases in violation of the contract. And so there does need to be this communication of what the problem is, and maybe the manufacturer can fix it. Also, relationship. If the parties can find ways that their relationships will benefit each other and their relationship with each other is beneficial to both, that can be critical to this type of negotiation. It's not just a focus on price, but it's a focus on other issues that are important and on the relationship. If the parties realize and communicate that a continuing relationship is in their mutual best interest, then this type of negotiation can work well. It would also be great if the parties would start brainstorming. Now, this doesn't mean that everything that's thrown out there as an idea will be acceptable to either party, but it's a good thing to brainstorm possible options or solutions to the dispute. Maybe the manufacturer would like to cut back on spending on salespersons, and if they can make this deal work with the store, they won't need so many salespersons to try to sell to other stores, and they can devote more funding into making sure the manufacturing processes work, and also make available funding so that they can fix the television sets that have been sold that were incorrectly manufactured. That would be one type of option or solution that might make everyone happy. It might help the manufacturer save money on salespeople and continue in business. It might also help the store to have this ongoing relationship with a manufacturer that is devoted to making the store and their customers happy. Now, there also has to be some application or legitimacy. These have to be accepted standards that have to be applied. There have to be alternatives that are considered. So the manufacturer might be considering, do I need to work something out with the store, or should I file bankruptcy? Those are the type of alternatives that the parties need to think about. If they can't get agreement of the other party, what's going to happen? An alternative might be litigation, might be bankruptcy, those types of things, which are unpleasant alternatives, and that might help push a party closer to working out something or settling the issues. And then finally, the successful negotiation needs to end with a commitment where the parties make realistic commitments to do what they've said they will do. All right. Now, negotiation is the simplest, most common form, the cheapest form normally, of alternative dispute resolution, but there are other types. Now, remember, litigation doesn't stop you from using ADR techniques. Now, sometimes you will try to negotiate or do some ADR technique before litigation occurs or instead of litigation. But sometimes after litigation starts, you will still continue negotiating. In fact, that's quite common that cases may settle during the middle of litigation or right before the voir dire. And so you may have these types of disputes being settled in the middle, or there may be some type of mediation going on, or different types of things that can go on. So litigation doesn't prevent you from using ADR techniques. On the other hand, you can use ADR without ever having a lawsuit. A lot of people will use ADR instead of going to court. One thing to keep in mind as a business is that your contracts can provide for ADR to be used. Particularly, a lot of contracts will include a clause that says that if there is a dispute, the parties will not go to court, but instead they will go to arbitration. And there are some reasons why businesses may prefer that, including saving some expense, some publicity, saving themselves from the risk of a jury trial, and that kind of thing. If ADR is used effectively, a lot of costs can be saved. And it's not just money cost, but it's also possibly the time cost and the cost of energy, the cost of emotional issues, the cost of bad publicity that can occur with litigation. So ADR can be very valuable in business and otherwise. Now, cases often settle, and the reason is parties to litigation can be losers, even if they win the case. So a great example would be if you start a lawsuit and you're paying your lawyer by the hour and you're paying them, let's just say, $350 an hour. Well, that can mount up pretty quickly for the plaintiff and the defendant, and each party is normally responsible for their own attorney's fees. And so, why should the parties not try to settle early rather than making the lawyers the only winners? And so this is one reason why settlements can be pretty common and in many cases never make it to a trial. Also, there is some desire to resolve differences that is instinctive to many Americans, and businesses settle disputes with customers to retain goodwill and avoid fines. It's not good publicity for a business to sue its customer. Now let's look at a scale of these dispute resolution systems, or ADR systems. Well, trial and appeal is not really ADR. That's the thing that we've been talking about quite a bit. It's very expensive in time, cost, and emotions. And so that one is on this end of the spectrum, most expensive. On the far right is negotiated settlement because it's least expensive in time, cost, and emotions. In the middle, we've got mediation, which is second least expensive. Arbitration's kind of in the middle here. Focus groups are here, and then trial is the most expensive. So very important to compare and contrast these, and different ones will be important at different points in a dispute, or for different types of disputes, I should say. One area that some parties might use are focus groups, one type of ADR. This is when attorneys get some lay people to come and listen to their case, maybe take a day or so to listen to the case, and they make findings from the evidence provided by attorneys. It's kind of like a mock jury. It's not a jury trial. It's just attorneys basically putting on the evidence in front of some people to see how the the people react. That mock jury delivers a verdict. It's not a real verdict, but it's a way for the attorneys to see what this focus group thinks about their case. And sometimes this may be very revealing to one or both of the parties about the strength of their case and the likelihood that they'll win in front of a real jury. And so it may help the disputing parties engage in more meaningful negotiations. A more common thing to use is arbitration. Now remember, arbitration is here, and so trial and appeal is the most expensive. Focus groups are also kind of expensive and oftentimes then will lead to settlement but sometimes still go to trial. Arbitration is here. More expensive than negotiation and mediation usually, but still a very good form of ADR and a very common form of ADR. What is arbitration? This is where the disputing parties, instead of going to court, they agree to have a third party, not a judge, but an arbitrator, decide the merits of the dispute. The arbitrator is authorized to make decisions that are binding on the parties and helps the parties to avoid litigation expenses and courtroom formalities. What's so great about arbitration? It will ease the congested court dockets, and so arbitration is now encouraged by the Federal Arbitration Act, and it's encouraged by the courts as a great way to go, and it is supported by the courts. In comparison, there's mediation. Now remember where mediation is on this, on here. Mediation's sort of a cheaper, less formal way than arbitration, but there are some weaknesses in mediation that we'll talk about. The mediator attempts to assist the disputing parties in resolving their differences. So, a good example would be a friend of mine a few years ago called me and said, my spouse and I are getting a divorce, and who's the best attorney for a divorce? So I gave him a name. Shortly afterwards, his wife, who was also a friend, called me and she said, we're getting a divorce. I need a great attorney. So I gave her a name of a great attorney too. I didn't handle the divorce because I didn't handle divorce cases and I would have had a conflict of interest. And so I sent this case out to two very good attorneys. The problem is the attorneys are also very aggressive. They spend a lot of time on the case because my friend happened to have a lot of money and property. Well, those attorneys were billing by the hour, and it was taking forever to get through this divorce. And finally, my friend called one day, and he said, I've heard about this thing called mediation. I'd like to try it because both my spouse and I want to be divorced quickly. We're tired of fighting. We also want to continue our friendship after we're divorced. And that's going to be hard if we continue this aggressive fighting between our attorneys. And finally, we're tired of paying attorneys' fees for months and months and months. They're just mounting up, and we're nowhere near going to court or settling this divorce. So, my friend found a mediator. The mediator sat down and in one day got the parties, husband and wife, to agree on all the property division. And they did sign a settlement agreement. Now, the weakness is the mediator cannot impose a binding solution on parties. The arbitrator, on the other hand, does make decisions that are binding on the parties. So keep that in mind. That is a key difference. But the mediator lets the parties have some control, but they do guide the parties in basically discussing some of the things that they need to discuss and kind of give them a format or an agenda for the day of mediation or however many days it takes so that they can discuss the issues and hopefully settle them. I've heard of great examples of this working in many cases. Another divorce case I heard about was not just about money, but it was about photographs of the children, for example. If one party finds those priceless and the other party does not, that kind of thing can come out in mediation in a way that it might not come out in court. Those types of things can be discussed. They can use the interest-based negotiation skills instead of just position-based, saying we're just going to split everything in half. You can have interest-based negotiation. So one party might find the sentimental value of the photographs worth a lot, while the other party may find that the most important thing to them is to have some good visitation schedule with the children. Those types of things can be mediated. Of course, the settlement still has to be approved by the court, but oftentimes it will be. Now, there is also a possibility for a lot of other things. There can be a combination of systems. You can have mediation in combination with other systems. There's a process called MED-ARB, where the parties, they go through mediation, they resolve what they can that way. And after they agree on everything they can in mediation, they arbitrate the unresolved matters. That keeps them still out of court and keeps the arbitration down to just the things they can't work out in mediation. So the law is encouraging you to be creative in using ADR systems, and that's certainly wonderful for business. Example would be the Magnuson-Moss Warranty Act. It provides that if a business adopts an informal dispute resolution system to handle complaints about its product warranties, then a customer cannot sue the manufacturer or seller for breach of warranty without first going through the informal procedures. It allows a manufacturer to require mediation before the complaining consumer can litigate. So, laws encourage ADR. Business people are more and more increasing their use of ADR, and so this chapter is very important for the success of American businesses. Thank you very much.